after this thing after this thing goes live, we'd like to welcome you as well. This training is part of our EEOC 2023 Joint Innovation Project. And like I said, it's titled The Pitfalls of Reasonable Accommodation. For those of us that are in this business, it's been a pretty eventful year as far as Supreme Court rulings, new laws taking effect, as well as locally we've had a couple new laws, and even here recently where there's discussion about changing our local law to add different protections as well. So in looking at this training, I thought the best way to go about it, it seems like whenever we get asked to go do trainings for employers or housing providers, we always say the mantra, treat everybody consistently across the board. And you'll stay out of the trouble. Unfortunately, there's three areas where you can't treat everybody like everybody else. You're going to have to treat people differently. And when I was thinking about, Pregnant Workers Fairness Act, as well as religious accommodation and disability accommodation, I immediately went to the game Pitfall that I used to play on Atari. When you go to these trainings, everything looks nice and black and white, and everything seems to be real easy. But once you encounter one of these kind of situations, it becomes that much more difficult. As a matter of fact, I did an employment intake yesterday with an individual with this disability. And when I talked to her on the phone, previously, it sounded like pretty clear cut. But once you start getting into the layers of the case, it can be quite difficult. So that's what we're going to do today. We're going to talk about a couple of areas of the law where reasonable accommodation comes into effect. The first one we're going to talk about is the Pregnant Workers Fairness Act. We're happy to have Jeremy Sells. He's the local and tribal program manager for the Equal Employment Opportunity Commission's Indianapolis District Office. He's going to present, and we're going to have time for questions at the end. If you have any questions, we also have somebody monitoring the chat box. So if you want to throw something there on the chat box, that's fine as well. I will say that anybody after this training is over that would like to request a certificate of completion to email me, and I'll put the email in the chat, and you can send me an email with your name and address, and we'd be happy to send out a certificate for that. Likewise, if you're watching this after the live recording and you have questions, please feel free to reach out to either Jeremy, Ed, or myself, and we'll be happy to answer those. So without further delay, I'd like to present to you Jeremy Sells with the Indianapolis District Office. He's going to present on the Pregnant Workers Fairness Act. Thanks, Jeremy.
Well, thank you, Ray. Good afternoon, everybody, and I appreciate the opportunity to present this information today. The Equal Employment Opportunity Commission, we enforce the federal laws regarding discrimination, and we have a lot of state and local partners, Ray being one of them. So this is a great chance to present to this audience. And like Ray said, I'll try to leave some time for questions at the end. This slideshow is sort of preliminary because this law is so recent that our commission has not issued formal guidance yet. So if there are questions, I'll try to answer them as best as possible. But there may be some things that are as Ray pointed out, when you get down into the details, sometimes an answer is more difficult. So go ahead, and if I use my jargon, I will be calling this the PWFA. So which stands for Pregnant Workers Fairness Act, and it's a brand new law. Previously, pregnant workers could be covered under a couple of different laws, but we're going to go through this. There's going to be a lot of emphasis on definitions, because that's sort of with these legal trainings, you spend a lot of time talking about the definition of a word. We'll go over a few things like that. And so pregnancy discrimination, it's an interesting subject because sometimes people discriminate. They feel like they have good intentions to consider that maybe somebody can't do some kind of work. The cases, what this is mostly going to cover is when the employee says they're not able to do certain things. And I've worked for the EEOC since 1999, and there's been some changes throughout that time. Originally, under Title VII, which was amended to include pregnancy discrimination in the 1970s. And under that law, the theory of discrimination that things were analyzed under was called disparate treatment. So there was never a guarantee originally that an accommodation, if someone had a lifting restriction or needed a doctor's visit or whatever with respect to their pregnancy, there was not a guarantee that accommodations were part of that situation. Some employers would provide them just because they felt like they should. Other times people would maybe assume that a pregnant person can't do certain things. So as we go through this, hopefully it will become clear, what you should or shouldn't do. But later in time, so originally, as I said, the accommodations were more on a comparison basis. So if you would accommodate someone for a temporary medical situation, then you should also not discriminate against pregnancy and treat that differently as a temporary medical situation. Then later in time, the ADA, the Americans with Disabilities Act, it originally never included pregnancy as a disability because pregnancy itself is not a disability, but as the definition of what a disability is changed, then certain conditions related to pregnancy could have been considered disabilities. So then accommodations related to pregnancy might have also fallen under the disabilities law. So this new pregnancy PWFA, Pregnant Workers Fairness Act law, sort of combines these two situations, and I think it's fair to say that it does expand who's entitled to an accommodation, but it also clears up, so that if you have a need for an accommodation, then it should be provided unless there's a hardship, which that's been the standard under the Americans with Disabilities Act for a long time. So hopefully, as I go through this, if my explanation wasn't clear enough, hopefully it will become clear. So this law became active on June 27th. So if someone comes forth on or after June 27th saying that they need an accommodation related to their pregnancy, then the employer needs to consider the request. So here's where I mentioned that we're going to get into definitions. So we're going to talk about covered entities, what types of employers and whatnot are covered by this law. I'm not going to go too deep into what a reasonable accommodation is because I expect that Ray is going to do a little bit of that when he talks about disability accommodation. And this PWFA law adopts a lot of language from the ADA, so we can expect it's going to follow it very closely. We're going to talk about what a qualified employee is, a known limitation, what being related to pregnancy, childbirth, or related medical conditions means, and we're going to talk about undue hardship, but again, that will be covered in the disability section as well. So covered entities, since this is, this is a law for the Equal Employment Opportunity Commission. Employers are covered entities. Our threshold goes down to as few, there have to be at least 15 employees. It covers federal agencies, unions, employment agencies. So there could be, joint employers sometimes when there's a temp agency supplying a worker to another company. And then reasonable accommodation, basically it's a change to the work environment that helps a person be able to work. Ray in the introduction mentioned, that sometimes an accommodation might require treating someone a little bit better than others. As far as discrimination goes, the logic behind that is that by providing a person with this accommodation, it does eliminate discrimination by giving them a level playing field to be able to access the work like a non-disabled person would be able to access. For example, stairs in a building with a person with a wheelchair, then they can't access the work like a non-disabled person. So a qualified employee or applicant that refers to that they can perform the essential functions with or without a reasonable accommodation. So that's going to be modeled in the ADA training, I'm sure. So this might be specific to the PWFA. So if you cannot do essential function, you will be considered qualified if the inability to perform the essential function is for a temporary period. So if an employee, says they need a standing restriction and, and they're late in their pregnancy, and they need this for, the last month or whatever, that's going to be a temporary period. And presumably they would be back to working in the near future. So that person is going to be considered qualified in terms of this PWFA. So this slide about known limitation really refers, it's similar to the Americans with Disabilities Act where someone has to request an accommodation. So it has to be communicated to the person in some way that the person needs an accommodation related to their pregnancy. And this is kind of just defining what an accommodation might entail. So the accommodation has to be related to pregnancy, childbirth, or related medical conditions. So maybe a person needs, to be able to go to the doctor for prenatal checkups, or maybe they're having leg swelling that's related to pregnancy, or maybe to, even after childbirth, you need a little bit of time off to recover from that. All of these things are going to be covered under PWFA as being related to pregnancy. Undue hardship, again, I don't mean to punt everything onto Ray, and feel free to chime in if you want me to expand on anything, but this is going to be the same language of undue hardship as the Disabilities Act, so that if an employer does not provide one of these accommodations, they would have to be able to explain why it is an undue hardship, that it would cause them significant difficulty or expense, and that's also in relationship to the resources and size of the employer. So again, similar to the ADA, there is to be an interactive process when a person asks for an accommodation like this. There should be some back and forth. It would not be a good idea for an employer to simply hear person ask for a lifting restriction as an example, and then just make a unilateral decision that that can't be that can't be taken care of, and just fire the person without any conversation as an example. There should be some back and forth to determine, is there an accommodation possible, and if not, there may not be one, but there should be some kind of process to reach that that point, and both sides are to participate in this interactive process. So someone may bring in a physician's note that says this person needs light duty, and then the company may have some questions for the physician of, well, here's the job description. What are the things that you're saying this person cannot do? Things like that are typical to the interactive process. So here's I'm going to read some of these as examples of reasonable accommodations, and these would be specific to, the PWFA. So breaks to drink water or use the restroom. Those are obviously things that pertain to the health of a pregnant person. Changing policies that maybe the person might need to have food or drink available. Changing equipment, such as providing a stool or a way to work while standing. Changing a uniform or safety equipment so that it fits, because obviously your body might change when you're pregnant. Changing a work schedule, a temporary reassignment, telework if it's not an undue hardship, leave for appointments, for medical appointments, light duty, or leave to recover from childbirth. These are all kind of anticipated accommodations. So this slide sort of alludes to the fact that there are other laws that also cover some of these things, such as leave. So the Family Medical Leave Act is administered by the Department of Labor itself. So I'm not a 100% expert on all the requirements of FMLA, but essentially most people have the notion that FMLA gives a lot of people 12 weeks of leave if it's needed. So, there is some overlap with these laws. So it might, I guess as one example is if an employer said, we cannot give off a person 1 week of leave to recover from their pregnancy. Well, if they are also covered by FMLA, they're going to have a hard time justifying why they can't give this week off, and they might be violating FMLA and PWFA. But the PWFA does say that it talks about undue hardship. So, but it would seem unlikely if you're required by one law that you could deny someone a leave, for example. So, and sometimes people could file if they, felt like they were denied something, one of their rights, basically. They might be able to file both an FMLA charge and an EEOC charge. So here's some, I'm going to read these as well. These are prohibited employment practices. So if there is not an undue hardship, then it would be unlawful to deny an accommodation to a qualified employer act. It would be prohibited to require an applicant affected by pregnancy, childbirth, or related medical conditions to accept an accommodation other than a reasonable accommodation arrived at through the interactive process. So, for example, forcing someone to go on leave if they could be accommodated to remain at work. Sometimes, as having worked here for a long time, sometimes you'll see people, employers feel like they're doing someone a favor by putting them on leave, but then if they didn't agree to go on leave, they may not feel like it was a favor. The next example is to deny someone, basically to not hire someone because you found out they're going to need an accommodation. That would be prohibited. To require someone to take leave, I kind of mentioned this example. Now, to take an adverse action in the terms and conditions of employment against a qualified person because they requested an accommodation. That would fall under retaliation, which I think is in one of these. Well, that's the next slide. So that's our segue. Retaliation basically is a basis for filing a discrimination charge if you've either opposed what you think is discrimination or if you've participated in the legal process by trying to avail yourself of your rights. So, for example, if you request an accommodation, it's unlawful to retaliate against the person for requesting accommodation. And it's also, retaliating against someone for filing a charge is similarly prohibited.
Right.
There's somebody needs to go on mute.
Could you please mute your microphone, please? Somebody that's on the phone.
It might be Felicia. Thank you. Thank you. So this is sort of a legal slide, but in order to exercise, this is the case with most of our EEOC laws, but in order to exercise your rights in court itself, you have to first file a charge. And then if the charge does not resolve the situation, then you can obtain a right to sue from the EEOC and then eventually file a charge in court. So it's sort of a process. And this lists the different kinds of relief that can be available. So injunctive relief, that means making an employer stop if they're doing an illegal. Is this thing on here the whole slide? Or sorry, I just see this recording message has been up on the slides the whole time. I apologize. Sorry, let me start back over here. I got distracted. So injunctive relief means making an employer stop doing something that's unlawful. So if they're discriminating or denying an accommodation that is that they don't have a justification to deny, then that would be injunctive relief would mean fixing that basically. Back pay or front pay could be types of relief. If it was found that a person lost their job due to unlawful discrimination, they could be entitled to pay or other types of damages, financial damages. And again, this slide just sort of mentions that how the PWFA uses language out of Title VII, as well as the Americans with Disabilities Act. So these are some examples of just scenarios that might happen. So a pregnant cashier asks her supervisor if she can sit while working at the register because of her pregnancy. Cashiers usually have to stand. So some of the things that in this example, the person asked if she could sit while, working because of her pregnancy. So she made this a known limitation. So that's kind of an important fact here. Assuming that she can do all of the cashier functions from a stool, then she would be qualified. So even though she may not be able to, maybe her doctor says you can only stand for 15 minutes, an hour, if she could do the functions from the stool, it would not be successful to argue that, she has to be able to stand constantly. And so the only defense for not providing this would that there would have to be some way to say that this presented an undue hardship to not allow this person to sit. And here's another, I think there are 4 examples. So in this case, again, the person asks for light duty. They have light duty. So in this example, the person asks for light duty because they cannot lift due to their pregnancy. They have light duty for workers with on-the-job injuries that excuses them from lifting heavy packages. So in this case, it's not immediately obvious how there could be an undue hardship. So this would likely be an accommodation that would have to be provided. As an example of how things are now versus before, under the previous laws, there could sometimes be arguments made that a person who was had light duty because of an injury was not being treated differently than a pregnant person because there are some kind of legal reasons to provide light duty for job injuries. So sometimes employers would deny the light duty for pregnancy, but give it to workers' comp situations. So under the PWFA, it sort of removes those kind of arguments because they're going to have, it would have, the only reason to not provide it is undue hardship now. There would no longer be an argument about whether the, pregnant people and injured people are comparable. It's not going to be a legitimate argument anymore, as far as I can tell. So here's another one. The person needs time off to attend therapy. They have not earned enough sick leave yet to cover their time away. So we can't tell from the example whether they have asked for the time off, but they would have to ask and make it a known limitation and explain why they were asking, I think. And then, so let's say that the employee hadn't been there long enough to get the sick leave, and maybe they're not covered by FMLA yet. The employer would have to explain why it's an undue hardship to not provide this. So the law does grant some extra requirements to help employ pregnant people. So this is another example where they need 8 weeks off. They do not qualify for FMLA, and they do not offer short-term disability leave. So again, it would depend on whether the employer can say it's an undue hardship to give leave. If they give other people leave, then that might be an argument why they can provide leave for pregnancy. So I think that I've been going for almost a half an hour. Does anyone have any questions about the Pregnant Workers Fairness Act? I'll just go over this last slide real quick then. So this is just some kind of best practices ideas here that it would be a good idea to train. If you're an employer, it would be a good idea to train your supervisors about this new law. First level supervisors may be likely to receive requests like this, and they should be trained about how to respond. So you wouldn't want to, have a supervisor deny someone a request or not relay a request and then result in someone filing a charge when maybe your company wasn't aware of the situation beyond the supervisor handling it at that level. This is advice to remember to use the interactive process, that the worker does not have to have a disability or something severe as long as the limitation is related to pregnancy. It doesn't even have to be a complicated pregnancy. Accommodations can be simple, and that the accommodation needs could change as the pregnancy progresses or as they recover from childbirth. Hopefully it wouldn't be the case, or maybe someone could get better or worse, depending on their medical, status. So there's also this resource called the Job Accommodation Network. This is actually really good for any types of accommodation issues. Sometimes they are aware of accommodations that, just to us average people may not even occur to us how an accommodation could be made. So if there are no questions for me, I want to thank everybody for your attention, and I will pass the baton to the next speaker. Thank you.
All right. Thanks, Jeremy. Again, does any last minute questions for Jeremy? He's kind of limited in what he can answer. But like he said, the EEOC has not officially issued any formal guidance yet, but certainly if you have any questions. Not, we will move on. Thank you, Jeremy. And
You, Ray.
I did have a question, not for Jeremy, but in general. Somebody sent me a question about the slide, the presentations. You can make your presentation available, Jeremy, to us to share?
Since this was approved for me to give the presentation, but in this case, since we're going to be issuing actual guidance relatively soon, I don't think that this is really a published document that
Gotcha.
the slideshow. But
Okay, certainly Ed and myself can
the
make ours
website.
available. Once we get the EEOC guidance published, we can certainly share it with everybody as well. All right. So next, as I mentioned, it's kind of been a pretty busy summer with respect to those in the equal opportunity field. One of those was a Supreme Court ruling earlier this year, which is Groff versus DeJoy, which kind of changed the landscape of religious discrimination and religious accommodation. So I've asked Commission Attorney Edward Dove to present on religious accommodation. So I will turn it over to Ed, and I will share his presentation here.
Okay, well, thank you, Ray. Yeah, before we get to Groff, I just kind of want to give you background on the religious accommodations. I have in my PowerPoint here a lot of Supreme Court cases just to establish that courts are basically, I don't know how to change these.
I'm doing it, Ed.
Oh, you're doing it? Okay. All right.
Yeah.
I just want to show the history of how the First Amendment, which is Congress shall make no law to abridge the freedom of religion. And if you look at some of these cases we cited in the Meyer decision, it starts out with the personal freedom to worship God according to the dictates of his own conscience. Now, that has been the theme basically from the Supreme Court through all our cases that we signed. Cantwell was an interesting case. Cantwell was children were basically giving out religious materials and were charged with basically using children in violation of the local law, and the court reversed the convictions, saying that that is part of their religion and they can basically was violated the First Amendment by charging them with any kind of criminal activity for practicing their religion. The other court, then we look at Everson, where the court's decision upheld publicly financed transportation for parochial children. That obviously is still the law. We still have issues, as we all know, about publicly financing private schools. It's issue in the campaign, but this Everson case, which is a 1947 case, upheld publicly financing for children, for parochial children. The Sherbert case is interesting. It gets into an area where we look at unemployment compensation, and basically the court ruled that the state must modify the unemployment compensation to allow a person to work Monday through Saturday in order to accommodate the employee who needs to be off for Saturday or Sunday religious purposes. Well, that's the accommodation. Obviously, 1963 was before a lot of the blue laws were struck down, which places were closed. But it does allow a defense for a unemployment compensation claim that you cannot work on Saturday or Sunday if you are being disciplined or threatened with termination because of your religious purposes or your religious beliefs. Now, the Wisconsin versus Yoder, it's again another accommodation under the First Amendment, where the state requires children to attend public school until 16. The court struck that down because of the Amish Mennonite Church refused to send the children after 8th grade. The court found that was accommodating their religion under the First Amendment, and therefore sided with the parents. So Hardison is an interesting case because it was a member of the Worldwide Church of God and refused to work on Saturday. The employee was transferred from Saturday to Sunday to accommodate his beliefs, but it was transferred. He lost his seniority and requiring him to work on Saturday. The court sided with the employee, and this is the first time that the court has really addressed what you've seen there with Jeremy, and you'll see with Ray, the undue hardship of the employer. If the employee asks for an accommodation and that accommodation cannot be granted without undue hardship to the employer, then that's a consideration. And that came from the Hardison case. I stuck in this employment division versus Smith because I kind of thought it was interesting. The two employees were employed, were terminated after ingesting peyote, which they alleged was part of their the religious ceremony of the Native American Church. The Supreme Court sided with the unemployment department, not because of the peyote was a religious part of their religion. It was because it was the misconduct because peyote was illegal. So that gets into the issue of basically a bona fide religion does your employee who's asking for the accommodation have a bona fide religious belief? And we've seen those cases basically recently in the Masterpiece Cake case, Hands on Originals case, where we're looking at closely held religious beliefs and whether they can be accommodated. The Burwell case, which I think everybody knows, is not really an accommodation case, but it is an important case because Hobby Lobby argued that they did not have to comply with the preventive reproduction care due to the Affordable Care Act. It violated their religious beliefs. The court sided with Hobby Lobby. Basically, Hobby Lobby was, did not have to provide this preventive care. So arguably, maybe it's accommodation, maybe it's not, but they did side with it. Then that brings us to Groff versus DeJoy. Now, the interesting thing about Groff versus DeJoy, I think it's a good decision for it's under Title VII. It's not under the First Amendment. It's under Title VII, and that they have finally, since TWA versus Hardison, they never really gave a definition of the hardship test. Now the court has found that it must show more than the de minimis cost to satisfy the undue hardship test. Now, that's not the way it is obviously Ray's going to talk about. This de minimis test cost is good for employees for requesting their accommodations for their religious practices. The court also held that bias or hostility towards a religious practice cannot supply a defense. Now, that's interesting because obviously we know in this nature, this time that we're in, there's a lot of bias and hostility towards a lot of people, religious and minorities. But under the Groff versus DeJoy case, it basically says that you cannot use bias or hostility to a religious practice or accommodation. It would not supply a defense. So, I mean, Groff, I think, is with defining more than the de minimis cost, is basically helps an employee receive his accommodation for religious purposes. The burden shifts almost to the employer to show that the undue hardship is more than just de minimis. So, like Ray said, the Supreme Court has definitely well, let's skip that slide, Ray. Let's skip that slide. All right, now let's go Title VII, which is what we all we definitely enforce here at the commission. And it said the person prohibits a person shall not suffer discrimination based on religion. Title VII is basically the all where most religious cases will appear at the commission or appear in court after receiving the right to sue. First Amendment is basically been, I would say, not eaten up, but those other cases now Title VII has taken basically precedence over that. To prove a Title VII case based on religion, you use the McDonnell-Douglas Corporation versus Green formula, meaning that the employee has a bona fide religion, the employer knows of the religion, and the employer has asked for an accommodation. The employer has denied the accommodation, and the employer has the burden to show the undue hardship, which is now needs to be more than de minimis. Yeah. So the Kentucky Civil Rights Act also prohibits discrimination based on religion. The Kentucky Civil Rights Act, if you look at the case, that seminal case in Kentucky is this Irvin case, which basically was decided against the employee because the employer had made an accommodation for the employee, and the employee basically wanted another accommodation. But the Court of Appeals found that the had provided a reasonable accommodation to accommodate the religious beliefs. We don't see a lot of the cases, Title VII cases, or 344 cases based on religion. And so, but I think the accommodation that Groff versus LaJoy has changed to the standard of more than de minimis is definitely going to be maybe bring more cases to the commission to or to the EEOC requesting accommodations. So that's about it. Any questions? No.
All right, thanks, Ed. I was loading my presentation up, so that's why I took a little bit long. Any
Okay.
other questions for Ed while we're chugging along here? Oh, what happened here? All right. Being none, we'll go ahead and move to the next part. Share screen. So what I'm going to do is I'm going to do some light lifting and do disability discrimination. Historically, at the commission, when we do employment cases, race has always been the number one basis that people file under. Probably within the last 5 years, we've had both disability and race kind of neck and neck every year about what the top basis is that people file at the Human Rights Commission. A lot of people know, you can't discriminate against people based on disability and hiring and firing and things like that. But again, one of the pitfalls, like in our title of our presentation, is the reasonable accommodation. This is what trips a lot of people up. So in order to unpack reasonable accommodation, we got to unpack the issue about disability discrimination. Back in the day, EEOC used to give us they'd come to town for a TAPS program. It was a very great program. They always used to give us these books, and there'd be a book on race discrimination. There'd probably be about that thick. Sex discrimination was probably about that thick. And then when we get disability discrimination, it was probably about the size of a telephone book. So when we're training investigators, some of our best disability related discrimination investigations, we spend a lot of time figuring out, number one, is the person qualified individual with a disability? Can they perform the essential functions of the job? All of that stuff. And that's kind of what we're going to go through here. Let's see. Make sure. There we go. First of all, I'm going to tell you a little bit about this. I noticed we have some fellow members of other commissions in Kentucky joining us here today. So I'd like to welcome those who are with other human rights commissions. But to talk about a little bit about our enforcement authority, we're an independent agency of the Lexington Fayette Urban County government. We investigate complaints of discrimination in employment, housing, and public accommodations. And our categories are race, sex, age, national origin, disability, color, religion, familial status, and sexual orientation and gender identity. Of course, today we're here to talk about disability discrimination. When you look at the laws governing individuals with disabilities, Ed referred to a couple of them. As far as federal laws, you have the Rehabilitation Act of 1973, which our office, we do not have authority over state agencies or federal authorities. So the Rehabilitation Act of 1973 would not be something that we enforce, but that is a federal law. It pertains to federal contractors, and it pertains to disability issues. We got the Americans with Disabilities Act of 1990. Again, probably, I've been with the commission since 1997. Probably about early to mid 2000s, you started getting a lot of court cases that pretty much dismantled the ADA. There was a series of court cases that just made it almost impossible for individuals to be covered under the ADA, even if they had, even if they were qualified individuals with disabilities. So, and finally in 2008, they passed the ADA Amendments Act and basically kind of took ADA back to its original intent and it broadened the definition of disability and made it easier for coverage, because like I said, a lot of those court cases were like, well, except in this circumstance. Well, except in this circumstance. So it was really, really difficult during that time for people to be covered under the ADA. But the ADA Amendments Act took care of that in 2008. And that's still kind of the law of land that we go by today. Of course, state law, you got the Kentucky Civil Rights Act, which you can find in the Kentucky Revised Statutes, Chapter 344. That's enforced by the Kentucky Commission on Human Rights. And of course, in Lexington, we have Local Ordinance 199-94 that basically adds disability as a protected basis, and that covers employment, housing, and public accommodation as well. Again, with the Americans with Disabilities Act, we're kind of going to go over coverage. Jeremy mentioned it, and it kind of derives from Title VII, which Ed discussed. That's basically your employment law. Americans with Disabilities Act is enforced by EEOC as well as local commissions that have the proper authority to do so. And we'll talk about filing here a little bit. Now, when you look at the Americans with Disabilities Act, it prohibits discrimination against individuals with disabilities through the following 5 titles. Title I was your employment. That's what we're going to talk about today. It covers all employers with at least 15 employees, like Jeremy mentioned in the PWFA presentation. Title II deals with state and local governments. It covers all programs, services, and public activities. But Title III is your public accommodations. It covers restaurants, stores, places of public accommodation. We do enforce that as well. We are the agency within Fayette County that if you're denied access through a public place, that is covered under public accommodations. Title IV is telecommunications. Every state must have a message relay service. And then Title V is miscellaneous provisions. And I looked that up just in case you're wondering what would be a miscellaneous provision. Its relationship to other laws. It could be impact on insurance providers, benefits. It does prohibitions against retaliation and coercion, and also discusses the illegal use of drugs and attorney's fees. So it's Title V is kind of like the catch-all that's not covered in the previous 4 titles. But like I said, what we're here today is talk about Title I, which is employment discrimination. Basically says no employer shall discriminate against any qualified individual with a disability in regard to any aspect of their employment. And aspect of their employment, again, anything that could happen to you on the job, that's recruitment, the application process, your hiring, your firing, your leaves, layoffs, training, job assignments, promotions, benefits, employers sponsored events. We even use a term called terms and conditions, and that could be any aspect of your employment that's not covered here. Like I'm the only one that has to clean the toilet and everybody else gets a free pass and doesn't have to touch the toilet. That's something like that would be a term and condition of employment. And like I said, that would be a catch-all provision. So then we go into the whole aspect of who satisfies who is a qualified individual, because people think if they're going down the road and they have a disability placard in their car, then they're covered under the ADA, and that's just not the case. There may be some overlap, but the definitions is quite different. First of all, we got to find out who is a qualified individual. And this is a person who satisfies the requisite education, skill, expertise, and other related requirements of the job that's being held or desired. So number one, they have to be skilled at what the job we're talking about. And two, they have to, with or without a reasonable accommodation, they can perform the essential functions of the job. And we're going to unpack all these definitions here a little bit later as we go along, because we're going to talk about essential functions of the job. So this individual, to be a qualified individual, you must be able to perform the essential functions of the job with or without a reasonable accommodation. So first of all, what are the essential functions of position? It's fundamental responsibilities determined by the employer. And we're not getting into just marginal tasks of the positions. So the considerations we make is number one, the employer's judgment. Do you have a written job description? That's a good place to start. The written description prepared before advertising or interviewing. It's not that once they complain about disability discrimination, you go in there and you start, okay, we need to figure out what the essential functions of the job here and what job description is. No. So the job description has to be prepared before even advertising or interviewing for the position. The performance of the function is the reason the job exists. The consequences of the function not being performed. So what happens if this person just quits performing the job? Does the place fall apart? Can it be performed by other people? What's the case there? The amount of time spent performing the function of the job. A limited number of employees among who the performance of the function can be distributed if for some reason this person can't do it. The function is highly specialized such that the incumbent is hired for that expertise. And if it's a union kind of situation, it gets into the terms of the union contract. So now that we've determined essential functions of the job, now you can see why that guidance we got was as big as a phone book. What is a disability? And again, there's no certain list. There's not little thing that we can go down one side and go to the other and say, oh, yep, that's a disability. We have to look at it in several different ways. An individual with a disability is someone. There's three definitions. The person, number one, has a physical or mental impairment that substantially limits one or more major life activities. And in the slides following, we're gonna spend a lot of time unpacking that definition apart, because there's different parts of that definition that we can look at by themselves. Has a record of an impairment, or number three, is regarded as having impairment. The ADA also covers associational disabilities, which would be individuals who are associated with someone who has a disability. So if you have a disabled child, or you have a disabled spouse, or you're a caretaker for somebody, the ADA would also cover you as well. But before we get back into unpacking the first definition, which is actually having a physical or mental impairment, let's talk about the second and third definition. So the second one is have a record of an impairment. So this would be a situation where you have somebody that has had cancer in the past, and they are currently in remission. So currently they're fine, everything's fine, they can do the job, whatever, but they have a record of an impairment on file. That individual would be covered under the ADA. And third, you can be healthy, but if your employer regards you as having impairment, so you can be also covered under the law as well. And this is an interesting aspect. I had a pretty good case when I was an investigator several years ago. I had a case where an individual had broken his back in the past. He had a car wreck, broke his back. He had a number of surgeries. He was fine. He could do physical work, and he actually had a job. His job required a lot of heavy lifting. And during the course of his employment, the employer found out that he had had a traffic accident in the past and had previously broken his back. Once they found that out, the employer started treating him differently. They wouldn't allow him to do heavy lifting things, and they eventually terminated him because they were, quote, concerned about his back. So in that case, we had an individual who was not substantially limited in a major life activity, yet the employer regarded them as having the impairment. So they could qualify under the ADA based on that definition, which is an interesting aspect of the ADA. We've had several cases over the years under regarded as. So once we get into that, what is a physical or mental impairment? So again, any physiological disorder or condition, cosmetic disfigurement, or anatomical loss affecting one or more body systems, or getting to the mental impairment aspect, any mental or psychological disorder, such as intellectual disability, which was formerly termed as mental retardation, organic brain syndrome, emotional or mental illness, and specific learning disabilities. Again, when we train new investigators, not only do we have to train them as being minor league attorneys in a way, but we also have to teach them to being minor league physicians, because as I mentioned, there is no exhaustive list of disabilities that we can just check a box and just put somebody in that box. We have to go through a series of questioning to figure out if this person actually has a physical or mental impairment. Once we've determined whether or not they have a physical or mental impairment, we have to look at what are major life activities. And this is basic actions that the average person in the general population can perform with little or no difficulty. Examples include breathing, ingesting, sensing, thinking, reading, speaking, interacting with others, reaching, standing, bending, working, sleeping, caring for oneself, learning, concentrating, communicating, writing, sitting, manipulating, walking, and lifting. And what else are major life activities? You get into the major bodily functions. So it's not only a specific activity, but certain functions of aspects of your body. For example, your respiratory system, circulatory system, brain functioning, immune system, endocrine, musculoskeletal, genitourinary, bowel, reproductive, cardiovascular, neurological, special sense organs, lymphatic, hemic, normal cell growth, digestive, and bladder. Then we get into, now that we have what is the impairment, what is the major life activity, we then look at the part of the definition is what is substantially limiting in a major life activity. That would be number one, unable to perform a major life activity, or you're significantly restricted in the condition, manner, or duration of performing the activity compared to most people in the general population. For example, you have trouble walking long distances or something like that. You can still perform it, but you're significantly restricted. And that differs with people in the general population, which can walk a lot farther without being in pain or getting winded, something like that. Other considerations, an impairment that is episodic or in remission is a disability if it would substantially limit a major life activity when active. Examples of episodic impairments or impairments in remission, that would be schizophrenia, depression, diabetes, epilepsy, multiple sclerosis, HIV and AIDS, or cancer. Before I get onto this, I will say, a lot of people come in and they'll check mark something, and you find out they're just kind of have a temporary impairment. Say like a couple years ago, I was doing some things and I tore my ACL. Something that is temporary in nature that's going to get better is typically not considered a disability under the Americans with Disabilities Act. Of course, you have to evaluate things on a case-by-case basis. For example, if something happened, an infection set in or something like that, and it ended up being more permanent in nature, then that would cross the line under a substantially limiting condition. So we can't, like I said, even though we've got these nice little definitions, each case is very different, and you have to really do a deep dive into these individuals and what their impairments are and how how that affects them. Additional factors in determining whether an individual is substantially limited. The determination of whether an impairment substantially limits a major life activity excludes the cumulative effects of mitigating measures. Mitigating, and the exception would be for corrective measures. Mitigating measures include medical equipment, low vision aids, hearing aids, and implantable hearing devices, prosthetics, mobility devices, alternate devices, adaptive equipment, or assistive technology, auxiliary aids and services, and learned behavior or adaptive neurological modifications. So excludes these. Like I said, a lot of the cases I mentioned in the early 2000s, there was some court cases out there said, hey, if you used a mitigating measure, you were not considered disabled. But like I said, with the Amendments Act, it kind of, again, broadened the definition of disability and made people to be able to fit under that a lot easier. When we're looking at, as I mentioned, like that first or second slide I had, we talked about pre-offer. We talked about hiring process, getting the job descriptions. Well, there's also some disability related questions and medical examinations. For example, if you're in the pre-offer stage of employment, inquiries into a person's disability is prohibited at the pre-employment stages, which includes the application form, the interview process, the physical exam or health history, third-party sources such as previous employer and background checks. An exception to that would be a bona fide occupational qualification, affirmative action tracking and selection, but this must be maintained separate from the application. Or if there's any other state or federal laws that come into play, that would be an exception as well. So when you're in the pre-offer, you can't get into the person's disability related information. Now, during the hiring process and interview, you may inform an individual of the requirements of the hiring process. For example, there's going to be an interview, there's going to be a written timed exam, going to be a job demonstration, whatever it may be. And you may ask if the individual will need an accommodation. That's a question that we ask when people apply at the Human Rights Commission is, can you perform the essential functions of the job with or without an accommodation? So you can ask if the individual will need an accommodation. You may ask if the individual can perform the essential functions, like I mentioned that we do here. We may ask the individual to demonstrate or explain how they would perform the essential functions, as long as all applicants are asked. Again, like I alluded to earlier, you treat everybody equally in that situation. If you're going to ask this person, ask everybody. And the exception would be if the person has a known disability, you may ask how the individual will perform the essential functions of the job. Prohibited questions. This is the big no-nos. Questions about an individual's impairment, questions about an individual's use of medication, questions about workers' compensation history, and obviously questions about mental health treatment may not be asked. Again, under the ADA, discrimination can take many forms. Disparate treatment, that's what we've referred to as treating somebody differently than somebody else. You get into disparate impact. That may be a neutral rule. If you have a neutral rule at work or a neutral policy that's in your employee handbook, but when you take that rule and you apply it to everybody, it may have a adverse impact on a certain class of individuals. In this case, it might include disability. So if there is some sort of rule that could be discriminatory in its intent, then that can fall under disparate impact, and it is illegal under the Americans with Disabilities Act. Harassment / hostile work environment. A lot of people checkmark this. I probably about every 3 or 4 people that come in check harassment. Now, harassment under what the Human Rights Commission does is actions, words, or something done to you based on a protected category. It's not because, oh, my employer follows me around and tells me what to do all the time. That's the employer's job. But harassment is phrases or actions done to you because specifically done to a protected category. Retaliation, some of our bigger cases fall into retaliation. And under retaliation, or what we do is if you oppose a practice, or in this case, you request a reasonable accommodation, or you have an individual on your job that you that filed a complaint of discrimination and you participate in that investigation, your employer cannot take any kind of action against you for exercising your rights under the law. In this case, if something happens under the ADA, person speaks out and says, hey, I feel like I'm being discriminated against, it is against the law to retaliate against somebody. And again, some of our better cases, once they're filed, the original thing that the individual filed on, it may get dismissed, but because the employer retaliated against them once the complaint was filed, then we're able to discuss further and either settle it or take it to a public hearing. And of course, the big one that we're going to talk about here a little bit when we get back to our pitfalls is failure to provide a reasonable accommodation. This is a lot of information being thrown at you. Are we good? Anybody have any questions so far? We still got EEOC on the line, so he could help answer those questions as well. If not, okay, reasonable accommodation. Again, like I said, a lot of people know you can't hire, you can't fire based on disability. What trips people up, the pitfall that we fall through, is the reasonable accommodation. The employer must provide a reasonable accommodation to individuals with disabilities in the workplace unless it would pose an undue hardship. And again, a reasonable accommodation is any change or modification in the workplace or in the way work is done that provides equal opportunities for individuals with disabilities. Some examples of reasonable accommodation. It would be a provision of alternative parking arrangements. I have to park in the way back in the back lot where all the employees park. I have a mobility impairment. I ask the employer to, hey, make an exception for me and make some disability parking near the back door where it's easier for me. Alteration of available facilities to be physically accessible and usable. Adjustment of the job application process. For example, let's say you needed special accommodations like an ASL interpreter or something like that. That would be a reasonable accommodation in the job application process. Provision of an alternative work format of work material. Acquisition alternate devices, adaptive equipment, or assistive technology. Provision of qualified reader, writer, sign language interpreter, or other assistant, like I mentioned. Adjustment to testing or training. I can't do it this time, but I can do it this time. Modification of policy, procedure, rule, or practice. Restructuring of the job. Permission for a part-time or modified work schedule. Provision of an alternative work area. Permission for an extended medical leave. Or reassignment to a vacant job. Important things to know about reasonable accommodation. You can be asked for at any time during the application process or the period of employment. Got a couple of cases now where individual asked for an accommodation right at the beginning, right when they were getting ready to go to their interview. So that can be asked at any time. And again, there's no magic words, no phrases. The employer cannot come back and say, hey, they didn't specifically say they needed a reasonable modification or reasonable accommodation. There's no requirement that they use those words. Just, hey, something's going on. I need to do my job better. I have a condition. Can you do this for me? That would suffice. It requires the employer to engage in the interactive process. Jeremy Sells mentioned that earlier, the interactive process. The employers have to engage in that. If they just kind of put them off and say, no, we're not going to do that, then the employer would have a problem. But as long as they're engaging in that process, it's going to be easier for the employer to say, hey, we're trying to work things out. We're trying to do everything that we can. And you can refer employee to the reasonable accommodation policy or procedure. Not a lot of the bigger companies have that. Many of the places that we deal with, I don't think a lot of people have a reasonable accommodation policy per se, but refer people to that if your employer actually has one. So if you're involved in the interactive process with the employee comes to you and says, hey, I need this accommodation. What can you ask? You can ask for functional limitations in the job. How, what is it about the job that you're having an issue with? And let's look for possible accommodations. What can we do to help you be able to perform this job better? Do not make any inquiry about the diagnosis, the prognosis, symptoms or manifestations of the medical condition. Don't make allusions to the situation or make a judgment about the consequent changed capabilities of the position. And an accommodation may be denied. The employer does not have to provide a reasonable accommodation where they will show an undue hardship. Like I said, Ed and Jeremy both talked about that. If it's unduly costly or administratively burdensome, it interferes with others' rights or safety, or it fundamentally changes the way we conduct business. A lot of times, the employers that we deal with, we don't even get to the undue hardship because usually when accommodations are denied, the people are just at the beginning like, nope, sorry, we can't work with it. They don't even participate in the interactive process. So make sure that if you do encounter this, to engage in that interactive process, and what may be an undue hardship for one employer may be not an undue hardship for another employer. So if you got a mom and pop shop that has 20 employees, it's still covered under federal law. What's burdensome to that be different than someplace like Walmart. So again, you have to evaluate these on a case-by-case basis. So when you implement an accommodation, you need to follow the company policy. Usually a written request is submitted. Again, there's no magic words, and a notice doesn't even have to be in writing. As long as they communicate that something is needed, you have to work toward implementing that accommodation. Medical documentation can be requested only for disabilities that are not obvious. And if you have personnel files and you keep that medical documentation, that documentation is confidential, and you must maintain that in a separate file, separate from the employee manual. And again, intersection with other laws. We talked about FMLA. We talked about workers' compensation. Those are not areas that we deal with, but a lot of the cases that involve disability may intertwine with these. FMLA, workers' compensation. Somebody's got a disability, something might have happened on the job or something like that, or if something is acting up, they're going to need more time off. So just so you know that when you're dealing with the situation under the ADA, you may be encountering other laws such as Act or workman's compensation. So this is kind of a flow chart that kind of talks about how we conduct an investigation. We get a charge of discrimination. We conduct an intake with that individual. During that intake, we ask the who, what, when, where, why, how, what's going on. Sometimes when people come to our office, it's situations that we can't help them. So if you go to the left, or at least my left, it says complaint not accepted. We would refer that person to the appropriate agency. That would be such an example that somebody said, hey, I didn't get paid. I worked 15 hours for this employer and they only paid me for 5 and they owe me money. That would be a Department of Labor issue. So we would refer that person to the Department of Labor. In the middle, you got pre-complaint conciliation. We do that in our ADA complaints. If we have, as far as our public accommodation, we get a notification that a certain business is not accessible under the Americans with Disabilities Act. We go out and we verify the violation, and then we notify the place of business and say, hey, you're in violation. Here are the regulations. Would you like to settle this case before a formal complaint is filed? Usually it's been about 99% effective for us. We're able to get that thing resolved, and they send notification. For example, a big issue is not an adequate ADA parking. There's certain chart that says if you have certain amount of parking spaces, this many have to be reserved for ADA parking. We would tell that tell that business, and they promise to do it, and then they provide proof that once that's completed, case is closed under what we do. So after we conduct an intake, we determine that this is something that we are going to deal with. It's jurisdictional. We accept that complaint. We send that complaint off. They have a certain, if it's employment related, they have 20 days to provide us a written response. Once we get that in, we do an investigation. The investigation can consist of requesting documents, speaking to witnesses, going on site, looking through records. At the same time that we do an investigation, we try to work with both parties to see if some kind of early resolution can be worked out. So, for example, we work with both parties, and the person says, "All I want is this accommodation." The employer comes back and says, "All right, we agree to do that." Everybody signs off on the agreement. Case is over at that point, and that settlement agreement can be enforced in court. If we're unable to resolve it, we have to go ahead and complete the investigation. Once we complete our investigation, we submit what's called a LOD, which is a letter of determination. Case can go one of two ways. We can go no cause or probable cause. If we issue a no probable cause, all parties are notified. There's a certain period of time. The individual has 20 days to file an appeal. And again, during that appeal process, they have to present new and additional information that was not already considered in the investigation process. If they don't submit any new additional information, or they do not formally request an appeal, case is dismissed. We have a board of 14 commissioners who would get involved in the appeal process. They take those cases on a rotating basis and determine what to do with them during the appeal process. If we issue a letter of determination and we feel like probable cause took place, we then issue our formal probable cause to everybody, and then we invite the parties to conciliate the case. We offer staff conciliation. We offer commissioner conciliation. So if any one of those two processes we reach an agreement, again, some of our better cases that we have, an argument could be, well, you guys don't probable cause a lot of cases. Well, a lot of our better cases that have merit, as you can see during our workflow here on our nice little chart, there's several opportunities to conciliate the case. And even if we find probable cause, guess what? We're still going to offer the parties an opportunity to work it out. So if they work it out after post probable cause, we sign everybody up on an agreement. Commission order goes out, case is over with. If the parties at that point still cannot reach some sort of agreement, it's issued, goes before our board and gets a failure to conciliate. And then at that point, we give it to Ed Dove, our commission attorney, who takes it to an administrative hearing. The administrative hearing, it's heard by an independent hearing examiner, and the same rules of evidence and court and all that stuff still apply. And after that point, the hearing examiner decides whether or not they agree with our decision that it's a probable cause. And if they agree with us, they'll also make a judgment on what kind of damages this individual is entitled to. And then once the hearing examiner makes their ruling, it then goes before our board, who can accept the ruling, reject the ruling, or they can also vote to amend it in some form or fashion, hopefully using the backing of the law to do that. We've had that happen in the past, where we got a ruling and the hearing examiner issued, like, I don't know, let's say $20,000, and it went before our board, and they felt like that was given the allegations, that wasn't a good enough settlement ruling, so they used the backing of the law to change that. So that's kind of the way our process works. Again, most of our complaints are employment related. Next one is housing. We do a lot of disability related housing issues as well, as far as accommodation, things of that nature. And we here lately, we've gotten a lot of disability calls. We got several employment cases that are disability related. We got couple of good fair housing ones that are disability related. And just about a couple months ago, I got a case where an individual was kicked out of a restaurant because they had a service animal, and it was just blatant discrimination. So discrimination based on disability is real. It's one of, like I said, it's always neck and neck with race discrimination on the cases that we file. It's not an easy area of the law. And like I said, I did an intake with a lady yesterday who it seemed pretty clear cut, but after I got to talking with her, it's not going to be that easy. And I don't, based on her allegations, I don't even know if it's a viable allegation under the Americans with Disabilities Act or not, based on several issues. So it'll be interesting to see. But when the investigators get this, we have to go through this kind of analysis that I just took you guys through. What are the essential functions of the job? What is this person's substantially limiting condition? Can they do the essential functions of the job with or without an accommodation? And from there, what happened? Were they fired? Were they not hired? Were they denied a reasonable accommodation? And we have to go through that analysis, kind of like we talked about disparate treatment, that analysis of how they've been treated with respect to other people. So it's not an easy area of law. What I like to tell people in this, when I do these kind of events, don't think of our agency as an after the fact agency. And if there's some people here that are joining us outside of Fayette County, we have very qualified individuals in other commissions across the state. We got the Louisville Human Rights Commission that investigates cases in Jefferson County. And then the Kentucky Commission on Human Rights, they have jurisdiction within all of Kentucky. And of course, we got our federal partners, the EEOC, who has across the nation. Feel free to reach out to us and give us a call. I don't like to say I don't like to call it advice because we're not allowed to give advice, but certainly we can offer technical assistance if you got something going on. Because like I said, when I was thinking about a good title for this presentation, I immediately went to Pitfalls, because we can, Jeremy's scenarios were great, but they look great in black and white, and they're like, oh, that was easy. Oh yeah, that's easy. I can handle that. But when you get these things that come across your desk, or these people in your office making these complaints, it becomes very difficult and can trip you up. So certainly, we're a neutral party. We don't represent people, but we're here to provide any kind of information and technical assistance. We also do workshops. We can do them in person. We would like to have done this one in person. However, due to some logistics, it was easy for us to do this on Zoom. So we appreciate you guys joining us on Zoom, but certainly we can come out to your place of employment. We don't charge for our services, so we can come out and teach your managers and employees how to deal with issues such as this. So another big one on the employment side is sexual harassment. So we do a lot of sexual harassment training, what you do if you encounter that situation, what's the manager's role, what's the employee's role. So we would be more than willing to come out to your all's places. And I'm sure the Kentucky Commission and Louisville Human Rights Commission would do that as well. So if there's any other questions, I think, trying to see, I got Emily in the chat, so I don't see anything in chat. So
I have a question. Ray,
well, Ed had thought of a question that on any of the presentations that have taken place.
I have a question, Ray.
Yeah.
I'm unfamiliar with the term administratively burdensome. Could you explain that a little bit better?
Sure. Ed, I'm going to defer to the lawyer on this one.
Oh,
Administratively burdensome would mean that the paperwork, simple answer, that the paperwork is just too much for them to process. So they would tell the employer or employee that, they just don't have the time to process it, basically. That is probably a weak defense. Does that help you at all?
yes, thank you.
Good question. Any others? Again, if you came on, joined us late, anybody, it's in the chat as well. Anybody have any questions after the fact can email me rsexton@lexhumanrights.org. And also we will provide a certificate of completion. If anybody is interested, would like a certificate for today, we will just send me your name and mailing address. We're also, if there's any attorneys joining us, we're still in the process of clearing this with for CLE credit. So there may be, they're very likely there's going to be CLE credit. The recording, this is being recorded today, and we were going to post this on our website, and we're also going to post it on our YouTube page. And given that it's going to be on there, we'll post it on our Facebook page as well. But we at Lex Human Rights is our Facebook, our YouTube, and everything. It's all the same. So go to our YouTube page and you'll be able to watch it back again. So any others, questions or comments? Okay. Hearing none, again, I thank you to EEOC. Thank you to Jeremy Sells. Again, this was part of our EEOC Joint Innovation Project for 2023. I appreciate Ed Dove, Commission Attorney, for presenting as well. And thanks to all of you that joined us today. We greatly appreciate it. And we'll talk to you soon. Thanks so much.